Good afternoon. My name is Kim Stanger. I'm an attorney with the law firm of Holland & Hart. I'm actually the head of our firm's health law group. And welcome to our next in the series of webinars that we provide on a monthly basis for clients. It's the holiday season, which means it's time for me to give my annual or semi-annual warning concerning gifts that you may either give or receive from potential referral sources. So the items that we're going to cover today, I'll go through quickly, give an overview of the relevant laws, and then I'll apply those laws to some of the common situations that you may face. Now, we're going to just be focusing today on gifts. We're not going to go into a lot of these laws in very much detail, and we're not going to really address other situations where the laws may be violated. For example, if you're providing something at less than fair market value or more than fair market value, we're not going to cover those. We'll be covering more of that stuff in more detail in January in our presentations there. If you have questions as we're going through this process, please feel free to send me an email, either offline or you can use the chat feature. Probably won't have time to take questions during the program, but I'll follow up with you afterwards. As far as written materials, you should have received an email that had the copy of the PowerPoint slides, an article that I've done on gifts to referral sources and patients, and some other additional helpful stuff from the OIG talking about gifts to and from referral sources. I've also given you a sample compliance plan standards of conduct addressing the gifts issue, which may or may not be helpful to you. If you do not receive those written materials, by all means, please let me know so that we can get those written materials to you. So, with that background, what's the big deal? Why does the government care about gifts? I mean, after all, it's the holiday season. Why does the government want to be the Grinch and get in the way of gifts? Well, the government's concerned that if you're giving gifts or receiving gifts, that those gifts or kickbacks may unfairly interfere with the decision-making process. It may result in overutilization because maybe the patient comes to you not because they really need the care, but because they want to receive the gift. Or maybe you have another healthcare provider who's going to make referrals to you, not necessarily because of the patient's best interest, but because of the gift that they get out of it. That can result in overutilization, increased program costs, corruption of the medical decision-making process, patient steering. Could also result in unfair competition because those who can give the bigger gifts can get more patients. So what did the government do about that? Well, they have enacted several laws that impact gift giving, including the federal Anti-Kickback Statute, the Ethics in Patient Self-Referrals Act, or STARK, the Civil Monetary Penalties Law. We're going to talk about those, the federal laws, but remember that there may also be state laws that are out there that may be impacted too. Let's talk first about the Anti-Kickback Statute. What does the Anti-Kickback Statute cover? Well, it's really the big arsenal in these things for the federal government. It states that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by a government health care program unless you structure that arrangement to fit within a certain regulatory safe harbor or statutory exception. Now, note that that is incredibly broad. It applies to anybody who gives or receives the gift with this intent to reward or induce referrals for federal health care program items or services. Now, note that it's an intent-based statute. Unlike the Stark law that we'll talk about in a minute, you got to have improper intent. But the improper intent is simply, it applies if one purpose of the remuneration is to induce referrals, even if there are other legitimate purposes. If one purpose is to induce or reward referrals, then that violates the Anti-Kickback Statute unless you've structured it to fit within one of those regulatory safe harbors. It's kind of hard to prove or disprove that one purpose was to induce referrals. It's kind of, if you're giving a gift to a significant referral source, then it's kind of going to be presumed that you're doing that in order to generate referrals. Kind of hard to disprove that. Also, ignorance of the law is no excuse. At least in the Ninth Circuit where I reside, it used to be an excuse, but in the wake of the Affordable Care Act, they eliminated that, so ignorance of the law is no excuse. But what happens if you violate the Anti-Kickback Statute? Nothing good. It's a felony. You can go to prison for a violation of the Anti-Kickback Statute, up to 5 years in prison, $25,000 criminal fine. In addition, under the Civil Monetary Penalties Law, you can get a $50,000 administrative penalty, treble damages, automatic exclusion from Medicare or Medicaid. If you self-report, the OIG has said under their self-disclosure protocol that the minimum settlement that they will accept for a violation of the Anti-Kickback Statute is a $50,000 settlement. So that can become an awfully expensive gift. In addition, in the wake of the Affordable Care Act, a violation of the Anti-Kickback Statute is also now automatically a violation of the False Claims Act. What does that mean? Well, the False Claims Act is a civil statute, so the government can go after you with a lower standard of proof. You can also get hit up with the False Claims Act penalties, which are $5,500 to $11,000 per claim you submitted improperly. You can be subject to a key tam whistleblower suit by a competitor or a disgruntled employee who decides to turn you in for paying these gifts. And if you did submit a claim to the government that was referred to you improperly as a violation of the Anti-Kickback Statute, hey, that's an overpayment. Therefore, you would have an affirmative obligation to report and repay that money that you received from the federal government under the False Claims Act, like we'll talk about in just a minute. Not good stuff. The Anti-Kickback Statute's evil cousin is the Federal Ethics in Patient Referrals Act, or the Stark Law, named after Representative Pete Stark. That says that if a physician or their family member has a financial relationship with another entity, that physician may not refer patients to that other entity for certain designated health services that are payable by Medicare and probably Medicaid. And if that physician does make an improper referral, that other entity may not bill Medicare for such designated health services unless that arrangement was structured to fit within a regulatory safe harbor. Well, what does that have to do with gift giving? Well, if you give a gift, and that gift has anything of value, then you have now established a financial relationship with that other entity, and you are potentially within the purview of Stark. So if Stark applies, you can't make referrals to that other entity. It doesn't prohibit you from giving the gift. It just says if you gave the gift, you can't make referrals to that other entity, and that other entity can't bill the government for any referrals you do make improperly unless you've structured the deal to fit within a regulatory safe harbor, like we'll talk about in a minute. Well, what happens if you violate Stark? Well, this is a civil statute. It's not a criminal statute, so you're not going to go to jail probably. But you can't get paid for services that were provided per an improper referral. In addition, if you were paid improperly, you've got an affirmative obligation to report and repay that within 60 days. If you don't, you can get hit up with a fine of $15,000 per claim you submitted during this period you had this improper financial relationship. Violation of the Stark Law can also, and usually does, also violate the Anti-Kickback Statute, so you could also get hit up with criminal penalties, and it will almost certainly also violate a False Claims Act violation, which will subject you to the additional False Claims Act penalties. Again, not very fun stuff. Now note that unlike the Anti-Kickback Statute, which is incredibly broad and applies to referrals to anybody, if it's going to reward or induce referrals for federal program business, Stark only applies to referrals by a physician to entities with which the physician or their family member has a financial relationship. So it only applies to gifts to physicians or their family members. Physicians are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, or chiropractors, or also any of those, their family members, as represented up there on the screen. Also, the Anti-Kickback Statute, incredibly broad, applies to inducement for any items or services payable by federal health care programs. Stark only applies if that physician is going to make referrals to you for designated health services payable in whole or part by Medicare or probably Medicaid, including the list of designated health services that are up there on your screen. So it doesn't apply to all services, but it applies to an awfully lot of services. That is Stark. The third prong of Satan's trifecta is the Civil Monetary Penalties Law. That kind of is a catch-all law that applies to a lot of misconduct. Among others, it prohibits certain specified conduct such as offering, soliciting, giving, or receiving remuneration to induce referrals, i.e. violating the Anti-Kickback Statute. But it also prohibits offering inducement to program beneficiaries, federal program beneficiaries, if you know or should know that the remuneration is likely to influence the beneficiary to order or receive items or services payable by federal or state programs from a particular provider. So the civil monetary penalties law applies to gifts you're going to give to federal health care program beneficiaries, your patients who are on Medicare or Medicaid or state programs. The civil monetary penalties law also applies if you have submitted a claim improperly to the government in violation of the Anti-Kickback Statute, STARK, or the civil monetary penalties law. You have therefore, if you receive payment for that improper referral, then you've received an overpayment and you've got an affirmative obligation to report and repay. If you don't report and repay within the deadlines, then hey, that is a violation of the civil monetary penalties law and the False Claims Act. What can happen if you violate that? Well, penalties under the civil monetary penalties law depend upon the type of conduct involved, but generally fines of $2,000 to $50,000. You can get hit up with treble damages, denial of payment, repayment of the amounts improperly paid, exclusion from federal programs. Civil monetary penalties violations can also result in False Claims Act violations. If they involve Anti-Kickback Statute or STARK, they may have those violations also. Again, not good stuff. Now, all of those lead up to the False Claims Act. The False Claims Act says, hey, you cannot knowingly submit a false claim for payment to the federal government. A false claim includes a situation where you have submitted the claim to the government in violation of the STARK Act or the Anti-Kickback Statute. That's a false claim. If you submitted it to the government, and even if you did it and you didn't know that it was a violation, if you subsequently learn that you've got an overpayment, that you've been paid improperly, you then have an affirmative obligation to report and repay the federal government within the later of 60 days or the date that the cost report is due if you're on a cost report basis. If you fail to do that, it turns into a False Claims Act violation, and the penalties can be all those that we talked about earlier. Now, those are the general federal rules that apply. But remember, you also may have your own particular state laws. All state laws, I think, have some version of the Anti-Kickback Statute. Some of those apply to just government programs like Medicaid. Some of them will also apply to private payers, too, so you got to look at that. Some states have their own mini STARK laws, self-referral laws. Others have disclosure laws, or where if you have a financial relationship, you've got to make certain disclosures. You've got fee-splitting statutes that might apply. Anti-rebate statutes may apply in some circumstances. The bottom line is, although we'll focus on our federal laws today, remember that there may be state laws out there, so you need to be familiar with the particular state laws that may apply in your particular state. Okay, with that background concerning the laws, let's apply them to some certain situations. First, let's apply those laws to gifts to referral sources. Well, it kind of summarizes it. The OIG has said that in some industries, it is acceptable to reward those who refer business to you. However, in the federal health care programs, paying for referrals is a crime. That is a violation of the Anti-Kickback Statute. Now, those gifts to referral sources, who are the referral sources? Well, it could be other providers or staff of providers, other facilities. It could also be payers. It could be vendors, it could be patients, it could be any others if there's gifts going back and forth in order to induce referrals. What kind of gifts? Anything of value. Could be cash, could be gift cards, baskets, food, wine or alcohol, meals, parties, tickets, events, services, free trips. Any other form of remuneration or item of value potentially triggers these statutes. Well, the Anti-Kickback Statute applies if you gave that gift and that you offer, give, solicit, or receive remuneration. Note that it not only applies to the giver of the gift, it also applies to those who receive the gift. It applies to anybody. If there was an offer, you offer, give, solicit, or receive remuneration, and one purpose of doing so is to induce referrals. Again, that may be difficult to disprove, but it only applies if there's an intent to induce referrals for items or services covered by a government health care program. It probably does not apply to referrals for private paid business. So if you're going to give a gift to a referral source, that referral source does not send you any government business because, quite frankly, you don't like government business. You probably don't have to worry about the Anti-Kickback Statute. However, if they are sending you government business, then you have to be concerned about the federal anti-kickback statute. Now, beware of state laws, because state laws may be more broad than the federal law, and they may actually apply to private payers too. Now, the anti-kickback statute does not have a de minimis exception. It's not like, well, if the gift is only, $100, then it doesn't apply. But the OIG has indicated in their compliance guidance for small group physician practices that the AKS may apply to soliciting or accepting or offering any gift or gratuity of more than nominal value. So it may be that as long as the gift is of nominal value, you probably don't need to stay awake at night worrying that the government's going to come in there and get you. The question, of course, then is, what is nominal value? And quite frankly, we really don't know. We do have some guidance when it comes to the civil monetary penalties law. I'm assuming that that would also apply to the anti-kickback statute. We'll come back to that in just a few minutes. So what's the bottom line on gifts to referral sources, to or from referral sources? And remember, referral sources can be anybody out there. It could be patients, could be other providers, it could be, anybody who might refer business to you if you've got some kind of a program. For example, I went into my dentist's office recently, and I saw that they've got some program that, hey, if you refer a patient to them, then you have the chance to win this Xbox. Well, to the extent that that dentist is providing federal health care program business, Medicare or Medicaid business, then that potentially implicates the federal anti-kickback statute. So if you're dealing with government programs, beware the anti-kickback statute, especially if the gift is of more than nominal value. If it's a gift simply to a private pay referral sources, well, it's probably less risky. You probably don't need to worry about the federal statute, but make sure that there's no state laws that are going to apply. All right, what about gifts to other physicians? Well, again, the anti-kickback statute is going to apply if one purpose of the gift is to induce referrals for items or services payable by government programs. In addition, you also got to be concerned about STARK. STARK applies if the gift is to a physician or the physician's family member, and the physician refers designated health services payable with Medicare or Medicaid to you. Unless you structured that transaction, structured that gift fits within one of the regulatory safe harbors. Now note, unlike the anti-kickback statute, for STARK, you don't have to have an improper intent. STARK's supposed to be a black and white law. It doesn't matter whether you've got good intent. It doesn't matter whether you intended to induce referrals. No improper intent is required for a STARK law violation. Now, because STARK only applies to referrals for private paid business, there is an argument, referrals for designated health services. If there are not going to be any referrals from that physician for designated health services, you probably don't need to worry about STARK, but that's probably a relatively rare exception. Now, STARK does have a few exceptions that may apply to gifts that you may want to give other physicians. First, maybe you want to give a gift to an employed physician. Can you go ahead and do that? Yeah, generally so. There's a STARK safe harbor. The bona fide employment safe harbor applies if the physician is a bona fide employee. The employment is for identifiable services. The amount of the remuneration under the employment agreement is consistent with fair market value and is not determined in a manner that takes into account directly or indirectly the volume of value referrals. There's the rub. You got to make sure that you're not giving this gift just because that physician is making referrals to you. And the remuneration is provided under an agreement that would be commercially reasonable even if no referrals were made to the employer. So if you're giving these gifts to all of your physician employees, that amount of that gift does not push them outside fair market value for their services, and you're not giving the gifts based on their referral patterns, then yeah, you probably don't have much of a problem. Well, what about if they're not an employee? There's STARK also has an exception for non-monetary compensation if you satisfy these criteria. It applies to gifts that you may give to physicians, medical staff members, or the like, so long as the items or services are not cash or cash equivalents, the aggregate value is less than $392, that's the 2016 rate. It's adjusted annually per CPI, so the aggregate value has to be less than $392 per calendar year. It's not determined in a manner that takes into account the volume of value referrals or other business generated by the referring physician, so you don't just go in there and identify your good referral sources and give them the gifts, but not the other people. Can't do that. It's not solicited by the physician or the physician's practice, so you can't go to the hospital and say, hey, I want my gift. It does not, and it can't violate the Anti-Kickback Statute or other state or federal law. What does that mean? One purpose of this gift should not be to reward or induce referrals. Now, in addition to that gift, that non-monetary compensation safe harbor also allows you to throw one annual party. It says that an entity that has a formal medical staff may provide one local staff appreciation event per year for the entire medical staff. And you can go ahead and do that in addition to the $392 gift that you gave to the physician throughout the year. But if you're going to provide additional gifts at the party, that still counts towards that $392 maximum. Well, what happens if you found out that, oh my goodness, we actually gave gifts amounting to a total of $450. We gave them a new iPod Watch or a new Apple Watch or something like that. Well, there is an exception under this safe harbor that says that where the entity has inadvertently provided non-monetary compensation in excess of the limit, that $392 limit, such compensation is deemed to be within the limit so long as the value of the excess is no more than 50% of the limit, whatever 50% of $392 is, and the physician returns that excess amount by the earlier of the end of the calendar year or within 180 days. So whichever is earlier, they've got to pay you back on that stuff. In addition, you can only use that once every 3 years for the same physician. So it does give you a little bit of grace period if you paid improperly, but there are limits on your ability to do that. So that non-monetary compensation arrangement, that is a good potential source for you if you want to give gifts to referring physicians. You just need to make sure you satisfy those criteria. There is another exception under Stark that allows facilities with a medical staff like hospitals to provide incidental benefits to bona fide medical staff members. If they satisfy the following criteria, you can give items or services that are not cash or cash equivalents. They have to be used on the hospital's campus for it, though. You know, it would be like things like maybe free meals for those physicians who are on call or something like that. It has to be offered to all members of the medical staff practicing in the same specialty without regard to referrals or business generated between the parties. It could be provided only during periods when the medical staff members are making rounds or engaged in other services that benefit the hospital or patients. It has to be reasonably related to the provision of services at the hospital. The value has to be less than $33 per item that you provide, and that can be adjusted annually per the CPI. And the kicker here, it cannot violate the AKS. What does that mean? Again, one purpose of that benefit that you're providing cannot be to induce referrals. There's also a safe harbor that will allow physicians to make charitable donations to a bona fide tax-exempt organization. That's probably not going to come up all that much. All right, so that's basically the rules if you want to give stuff to a referring physician. But what about gifts to patients? Maybe you want to reward those good patients that have been coming to you for a long time. Can you do that? Well, you can, but you got to make sure you're going to comply with the rules. First, the Anti-Kickback Statute applies if one purpose of the gift is to induce referrals for items or services payable to the government healthcare programs. And you're thinking, well, wait a minute. That patient isn't a referral source, are they? Well, yeah, they're referring themselves. So therefore, the Anti-Kickback Statute can apply. So you got to make sure that one purpose of that gift to that patient isn't to induce or reward them to receive referrals. Stark will apply if that patient's a physician or a physician family member. So that could apply if, for example, you've got a professional courtesy policy where you provide free or discounted care to referring physicians' families or other physician families. So you got to be aware of that. But most importantly, the civil monetary penalties law applies if you know or should know that the remuneration, the gift that you're providing, is likely to influence the beneficiary, a Medicare, Medicaid, federal program beneficiary, to order or receive items or services payable by federal or state programs from a particular provider. Now, lest you think that the OIG has no heart, the OIG has said they have interpreted the civil monetary penalties law to permit Medicare or Medicaid providers to offer beneficiaries inexpensive gifts other than cash or cash equivalents for services without violating the statute. For enforcement purposes, inexpensive gifts or services are those that have a retail value of no more than $10 individually and no more than $50 in the aggregate annually per patient. So the OIG says, hey, under the civil monetary penalties law, you can give your patients gifts so long as each gift that you give them is worth no more than $10. It's not cash or cash equivalent. And the total amount that you give a particular patient does not exceed more than $50 aggregate annually. So you can give your patients small gifts, at least under the civil monetary penalties law. Well, what about the anti-kickback statute? The anti-kickback statute does not expressly have any such exception, but remember that there is that comment that they will not really go after you for anything that is of nominal value, or at least they suggest that. I suspect that they would probably interpret nominal value consistent with this OIG guidance with regard to the civil monetary penalties law. But no guarantees. What about receiving gifts from patients? You've got a patient and they really like what you've done for them. Can you receive gifts from them? Well, if you're receiving the gifts from them, then it's probably not done to induce referral. So you're, I guess, unless that patient is a referral source or wants to get your referrals. But other than that, generally the gifts from patients don't generally implicate the federal anti-kickback, the federal STARK, those other situations. But you may want to make sure that you take a look at the AMA ethics opinion. The bottom line here is there are no definitive rules to determine when a physician should or should not accept a gift from a patient. You just need to make sure that you are not exploiting the patient. Be careful about accepting a gift that's worth too much under the circumstance. Make sure that there aren't strings attached to that gift, that there's not some kind of expectation that's going to interfere with your judgment. I've actually seen some cases recently where patients have a high deductible. They want their physician to maybe help them classify a particular visit in such a way so that it would be covered instead of a non-covered service, and maybe they're sliding something under the table in order to get that. Don't go there. That would be healthcare fraud. You don't want to do anything like that. What about gifts from vendors? You've got that vendor wants to come in and sell you a product or provide a service to you or provide you some kind of medical device. It could be, remember back in the heyday when you could get all sorts of trips or free equipment, supplies, meals, CME, sham service arrangements or other things from vendors. They're willing to come in there and give that to you. Well, those days are gone or should be gone because you got to be worried about the anti-kickback statute if that gift is going to induce or reward referrals for items or services payable by federal health care programs. So if that vendor is would bill federal health care programs for anything that you referred, then you got to be concerned about the anti-kickback statute. Again, remember that the OIG has suggested that nominal gifts likely would not be challenged, but we really don't know where they draw the line on nominal gifts. They drop off a free Penti, I'm not too concerned about. Maybe some donuts, that might be okay. If they're sending you to the Bahamas, I'd be a little bit nervous. Also, STARK applies if the physician refers patients to or orders designated health services from the giver. If that situation, if that vendor is a provider of designated health services, then that gift to the physician is going to trigger STARK, and you would want to make sure that you complied with the STARK law or that physician is not going to make referrals to that vendor. All right, there we go. Well, what about free drug samples? The OIG has said that many drug and biologic companies provide physicians with free samples that the physicians may give to patients free of charge. It is legal to give these samples to your patients for free, but it is illegal to sell the samples. Why? Because if you're selling the samples, then you're making money off that, so that vendor is essentially, giving you a financial remuneration. You're getting a benefit for that, and therefore that could trigger the anti-kickback statute as well as potentially other pharma laws. The AMA has come out with guidance. Again, this is not a statute or anything like that, but they have issued an ethical opinion dealing with gifts from industry vendors and others. The AMA says that to preserve the trust that is fundamental to the patient-physician relationship and public confidence in the profession, physicians should decline cash gifts in any amount from an entity that has a direct interest in the physician's treatment recommendations, decline any gifts for which reciprocity is expected or implied. I give you this gift, you do something for me. Or you should not accept, or you should You can accept an in-kind gift for the physician's practice only when the gift will directly benefit the patients, including patient education, and is of minimal value. In addition to AMA guides, the pharma industry, the medical device manufacturing industry, they also have their own internal code of ethics that focus a lot on when it is and is not appropriate to give or receive gifts in the pharma industry. If you have questions on that, you can look to that source. These issues became even more important with the passage of the Physician Payment Sunshine Act. The Sunshine Act requires that medical device and pharma companies, they've got to submit an annual report to CMS identifying payments or other transfers of value made to physicians or teaching hospitals. So if they're giving you these gifts, they've got to report that to the government. Now, it excludes payments of less than $10 individually or $100 aggregate on an annual basis, and certain educational materials and in-kind items for charity care. If they make that report for other things, then that report has to identify the name and address of the physician, the amount and date of the payment, the form of the payment, such as cash or stocks, the nature of the payment, such as consulting fees, gifts, or the entertainment expenses. If they make that report, then obviously that may increase the likelihood of a government investigation. In addition, those gifts have to, the report goes on this government website, so if your patients wanted to, they could go in there and do a search to identify whether or not you are receiving gifts from a particular manufacturer to determine whether or not your independent judgment has somehow been tainted. All in all, we'd probably prefer not to be in that list if we can avoid it. All right, that is a brief overview of the laws concerning gift giving this holiday season. Let's go back and summarize real quickly. Bottom line here is whenever you accept government money or participate in government programs, you got to be aware of the strings attached, including the strings that apply to your gift giving. Gifts to or from entities that are not involved in government programs are less risky, but there's no guarantees. You have to look at your state statutes. Gifts to or from entities that are involved in government payment programs, they may implicate the Anti-Kickback Statute if one purpose is to induce or reward referrals, but nominal gifts are probably okay, whatever that means. Stark is going to apply if the physician, if the gift involves either to or from a physician who may refer designated health services payable by Medicare or probably Medicaid. Then in that situation, you shouldn't be doing the gift unless you can structure that gift to fit within one of those regulatory safe harbors that we talked about. The civil monetary penalties law will apply if the gift would influence a government beneficiary to obtain your services, but you can give them a gift so long as it's up to $10 per gift and $50 aggregate for that particular patient during the year. Before giving or receiving more than a nominal gift, you should ask yourself, is the recipient a referral source for items or services covered by government programs, including you? Is the gift between referring providers, or is the gift to or from patients who are government beneficiaries? If they are, you've got to be a little bit concerned. And then ask yourself, why are you giving the gift or receiving the gift? Is it to thank them for past referrals or business, or to encourage future referrals or business? If it is, then one purpose of the gift is to induce referrals, and you've got to be concerned about the Anti-Kickback Statute if there is a potential for referrals for items or services payable by government health care programs. Why are you giving the gift to this particular person and not others? Is it because this recipient is a good source of business, or you hope to receive future business as a result of the gift? If it is, then one purpose of that gift is likely to induce referrals, and again, you've got to be concerned about the Anti-Kickback Statute. We've talked about the federal laws. Once more, you've got to be aware of your state laws. They may be broader than the federal laws. For example, here in Idaho, where I practice mainly, although we've got a regional practice in Idaho, their Anti-Kickback Statute applies to giving gifts to anybody who's a potential referral source, whether that's a patient, whether that's another provider, whether that's anybody else on the street. Common state laws, again, may include anti-kickback statutes, mini Stark statutes, fee-splitting statutes, rebate statutes, other types of statutes. So red flag situations when it comes to gifts, anytime you have gifts to or from sources who refer government program business, you got to be concerned. Gifts to government program beneficiaries, got to be worried. Gifts to physicians who refer designated health services payable by Medicare, hey, that's stark. Be concerned about that. Gifts that are based on referral patterns, gifts are only given to those who refer business, or bigger gifts are given to those who refer more business. That is probably going to cause some concern. Gifts to patients who receive significant services, or gifts that are given shortly after significant services were provided, all of those are situations where it certainly would appear that the purpose of the gift was to reward or induce referrals, thereby triggering potential state or federal laws against that. Well, an ounce of prevention is worth a pound of cure. The best thing to do, instead of getting a improper gift and having some kind of repayment obligation, is to make sure you avoid those situations to begin with. You ought to develop a gift policy that is part of your compliance program. It should have limits on gift giving. It should require compliance officer review before giving or accepting a gift of more than nominal value, for example, $10. Gifts received belong to the entity, not the individuals. So if those gifts are coming into the individuals, not particular entities, that lessens the risk that there is a potential to make improper referrals, or that you have employees out there going out trying to solicit gifts or refer business to get more gifts. Any questions concerning the policy should be directed to the compliance officer. Everybody has an obligation to report suspected violations to the compliance officer so the compliance officer can respond, and violations may be subject to appropriate discipline. Among the items that I provided in the written materials is a sample standard of conduct that has a gift-giving policy component to it. You might look at that and consider whether you want to incorporate something like that. You should implement a method to track gifts to patients or referral sources. If you're going to be giving gifts, make sure that you fit within that $10/$50 limit in the civil monetary penalties law. If you're giving gifts to referring physicians and you want to fit within the non-monetary compensation exception, make sure that you're going to fit within that $392 limit per year. Train your staff on the policy and document the training. You really ought to call up and look at the OIG's compliance program guidance. There's different guidance depending on whether you're a physician office or whether you're a hospital. You may want to look at that because there will be more information concerning gift giving. Now, if you go back and you find out that, oh my heavens, we did give an improper gift, then you got to make sure that you consider what your next steps are going to be. If you identify significant non-compliant gifts, it may prohibit you from referring to the giver or providing items or services in response to a prohibited referral from the giver. If you have received payment from government programs for items or services provided per an improper referral, you may and probably do have an affirmative obligation to report and repay amounts received from the government per that improper referral. That could be gifts in violation of the Stark Anti-Kickback Statute. The False Claims Act generally requires most healthcare providers, unless you're paid on a cost report basis, to report and repay the overpayments within 60 days. You may be subject to a False Claims Act penalties. The bottom line is, if you've got a violation of your gift-giving policy or these rules, regardless of what's in your policy, make sure you consult with your qualified healthcare attorney that can help you walk through those things. All right, now that I have completely decimated the Christmas cheer, if you still need additional resources, you can go to the government's website. The government has a great website on Compliance 101. You can access it there at the location on your screen, or just type in OCR Compliance. It'll take you there. It's got lots of different guidance, videos, things like that you can use for training. There are advisor opinions, special fraud alerts, lots of other things that can be a resource for you. That is it for my brief overview of these issues. If you have any questions concerning these items, feel free to shoot me an email and I can follow up with you, or send me a question on the chat function. We are in the process of planning our webinar series for next year. If there are any particular topics that you would like to have addressed next year, by all means shoot me those and we'll see if we can work those into the schedule. I think in December we've got a program dealing with OSHA, and also, if we can line it up, one on collection processes. In January, we typically address the fraud and abuse issues in more detail. In February, we'll be addressing a lot of HIPAA issues to get you ready for those self-reports that you have to do by 60 days after the end of the calendar year. And more fun stuff will come out throughout the year. We always appreciate your participation. Let us know if there's anything we can do to improve this. And thanks so much. Hope you enjoy the holidays despite everything that I told you today.